There's a question that many people don't think about when participating in politics, and that question is, what is the United States? Now this might sound like an odd question, but it's a very important one that must be answered before taking part. And this is because differing views of the country can cause much of the confusion and rifts between people when they begin to discuss the basics of how the federal government interacts with the states, or even how the states interact with each other. This is because there are primarily two views of the United States, and these two views have been clashing since before the ink was even dry on the Constitution. The first view of the United States is known as the Nationalist View. This view perceives the United States as fundamentally one entity. It is not a collection of states, a federation of states, a confederacy of states, or a league of states. It is a single whole. Our state boundaries have very little significance. They're primarily just arbitrary boundaries similar to the county or parish lines, but this delineation is of little other significance. We are also fundamentally one people, taken in the aggregate as opposed to separate peoples. The second view of the United States is what is known as the Compact View, or Compact Theory. This view holds that the United States is fundamentally plural. The states are the fundamental units of the United States, and they maintain their sovereignty and their rights of self-government. They came before the federal government, and not only did they come before the federal government, they created it. In point of fact, originally the proper way of referring to the Union was to say the United States are, showing the plurality of the Union. So which of these views is the correct one? Well, like anything else, that depends on who you ask. Many people, if they happen to entertain this question at all, already have their minds made up of how they view the United States. And once people have their minds made up, it can be pretty hard to change how they think or perceive something. These beliefs don't have to make sense or be based on any kind of actual facts. It's what they believe, and that's good enough. The nationalist view has been the predominant view that has been taught to people for most of the last century. This time period encompasses several generations, and so the majority of people today think only of the United States in this way. This single view of the United States, coupled with every person knowing the Pledge of Allegiance by heart, and it's pretty easy to see why this would be the predominant view. But it is very important to understand both views of our country if we are to have an informed and responsible discussion with things pertaining to it. So let's go through our nation's history to see which of these two views falls in line the best before you make up your own mind on the subject. One of the earliest works that fully fleshed out the nationalist theory's viewpoint was written by Joseph Story, an American lawyer and jurist who served on the Supreme Court of the United States from 1811 to 1845. Story wrote an exhaustive 3-volume work in which he details the nationalist theory viewpoint, entitled Commentaries on the Constitution of the United States, with a preliminary review of the constitutional history of the colonies and states before the adoption of the Constitution. Now this sounds like a long title, and back in those days, that's how titles were written. Most people just refer to the work as Commentaries on the Constitution of the United States. But only 7 years after Justice Story's work was published, and had circulated a bit, a rebuttal from the Compact Theory viewpoint was published, meticulously countering every one of Story's assertions. The writer was Abel Upshur, an American lawyer and judge from Virginia, who served as Secretary of the Navy under the 10th President of the United States, John Tyler, and who then became Secretary of State after Daniel Webster resigned. Upshur's work was entitled A Brief Inquiry into the True Nature and Character of Our Federal Government, being a review of Judge Story's commentaries on the Constitution of the United States. And by the way, both of these can be found in the dark roast section of Smell the Freedom under the Constitution tab in PDF format. One of the points that Justice Story gives to support his view is that during the formative years of our nation, known as the Colonial Period, the United States and its people began to solidify into one people and one nation. Justice Story asserted, although the colonies were independent of each other with respect to their domestic concerns, they were not wholly alien to each other. On the contrary, they were fellow subjects and for many purposes one people. Every colonist had a right to inhabit, if he pleased, in any other colony, and as a British subject, he was capable of inheriting lands by descent in every other colony. The commercial intercourse of the colonies, too, was regulated by the general laws of the British Empire and could not be restrained by colonial legislation. Story also quotes Justice John Jay, one of the writers of the Federalist Papers and first Chief Justice of the Supreme Court, who also held the Nationalist View, and stated, "All the people of this country were then subjects of the King of Great Britain, and owed allegiance to him, and all the civil authority then existing or exercised here flowed from the head of the British Empire. They were in a strict sense fellow subjects, and in a variety of respects one people." So did the colonial period begin to assimilate the United States into one people? Upshur responded that every one of these historical facts is the result of the relation between the colonies and the mother country, not the result of the relation between the colonies themselves. Although these facts do indeed prove a unity between all the colonies and the mother country, and show that these taken together are in the strictest sense of the terms one people, I am at a loss to perceive how they prove that two or more parts or subdivisions of the same empire necessarily constitute one people. So far as the rights of the mother country are concerned, they existed in the same form and to the same extent over every other colony of the empire. He continued, "Did this make the people of all the colonies one people? If so, then the people of Jamaica, the British East Indian possessions, and Canada are for the very same reason one people to this day. If a common allegiance to a common sovereign and a common subordination to his jurisdiction are sufficient to make the people of different countries one people, it is not perceived why the people of Gaul, Britain, and Spain would not have been one people while Roman provinces. They owed allegiance to the British king as the head of each colonial government and as forming a part thereof, but this allegiance was exclusive in each colony to its own government, and consequently to the king as the head thereof, and was not a common allegiance of the people of all the colonies to a common head. These colonial governments were clothed with the sovereign power of making laws and of enforcing obedience to them from their own people. The people of one colony owed no allegiance to the government of any other colony, and were not bound by its laws. The colonies had no common legislature, no common treasury, no common military power, no common judiciary. The people of one colony were not liable to pay taxes to any other colony, nor to bear arms in its defense. They had no right to vote in its elections, no influence nor control in its municipal government, no interest in its municipal institutions. There was no prescribed form by which the colonies could act together for any purpose whatever. They were not known as one people in any one function of government. Although they were all alike dependencies of the British Crown, yet even in the action of the parent country in regard to them, they were recognized as separate and distinct. They were established at different times, and each under an authority from the Crown which applied to itself alone. They were not even alike in their organization. Some were provincial, some proprietary, and some charter governments. So did the colonial period begin to assimilate the United States into one people? Well, there's no defined answer, but historically, it sure doesn't seem like it. So next we come to the Declaration of Independence and the formation of the Continental Congress during the Revolutionary War. Justice Story asserts that, from the moment of the Declaration of Independence, if not for most purposes at an antecedent period, the United Colonies must be considered as being a nation de facto, having a general government over it created, and acting by the general consent of the people of all the colonies. The powers of that government were not, and indeed could not be well defined, but still its exclusive sovereignty in many cases was firmly established, and its controlling power over the states was most, if not all national measures, universally admitted. Joseph Story is not the only one that viewed the Declaration of Independence in this way. James Wilson also held this view. Wilson couldn't admit the doctrine that when the colonies became independent of Great Britain, they became independent also of each other. He read the Declaration of Independence, observing thereon that the United Colonies were declared to be free and independent states, and inferring that they were independent not individually, but unitedly, and that they were confederated as they were independent states. so even from people of the time you're going to get conflicting views. But many of the colonies had already declared their independence prior to the 4th of July, 1776. They had commenced the revolution and were already considered by England as in a state of open rebellion. Of Virginia, this is emphatically true. Her Declaration of Rights was made on the 15th of May, 1776, and her Constitution was adopted on the 29th of June. That Constitution continued until 1829. The Declaration of Independence that we are taught about was actually more of a public affirmation of what most of the colonies had already performed by themselves. So let's look at Joseph Story's next assertion, that the Continental Congress created a nation de facto with controlling power over the states that was universally admitted. Was this in fact a government that represented the maturation of the United States into one people? Did the Continental Congress really do this? During that time, the colonies' primary complaint was that of oppression from the mother country, and they were anxious to devise some means by which their grievances might be redressed. These grievances were common to all of them. Their rights as British subjects had never been well defined, and some of the most important of these rights, as asserted by themselves, had been denied by the British Crown. The colonies were not independent, and had not even resolved to declare themselves so at any future time. On the contrary, they were extremely desirous to preserve and continue their connection with the parent country. So it was as early as 1765 a majority of the colonies had met together in Congress, more commonly called a convention, in New York for the purposes of deliberating on these grave matters of common concern, and they then made a formal declaration of what they considered their rights as colonists and British subjects. This measure, however, led to no redress of their grievances. On the contrary, the subsequent measures of the British government gave new and just causes of complaint, so that in 1774 it was deemed necessary that the colonies should again meet together in order to consult upon their general condition and provide for the safety of their common rights. These conventions were a deliberative and advisory body, and nothing more. Their acts appeared in the form of resolutions, rather than in the form of laws or commands. The body simply recommended these to their constituents, but commanded nothing. Each colony was free to act on these recommendations or not. In fact, it was a meeting of delegates from New Hampshire, Massachusetts, Connecticut, Rhode Island, parts of New York, New Jersey, Pennsylvania, parts of Delaware, Maryland, Virginia, and South Carolina. North Carolina was not represented until mid-September, Georgia not at all, and it's arguable that New York was not represented as a colony, but merely as different parts of New York. One gentleman from Georgia was admitted, but he did not vote because he was not a representative of his colony. He was simply a citizen of the colony of Georgia. And Upshur accounts for this. In point of fact, the Congress was a deliberative and advisory body, and nothing more. And for this reason, it was not deemed important, or at least not indispensable, that all the colonies should be represented, since the resolutions of Congress had no obligatory force whatever. It was appointed for the sole purpose of taking into consideration the general condition of the colonies, and of devising and recommending proper measures for the security of their rights and interests. He goes on to conclude that there were several more Continental Congresses through the years, and it became a functioning body throughout the War for Independence, but at no point was it ever a central point of force over the colonies. It remained simply a gathering of delegates from distinct colonies. So now we come to the actual revolution. Here, Joseph Story asserts that among the exclusive powers exercised by Congress were the power to declare war and make peace, to authorize captures, to institute appellate prize courts, to direct and control all national, military, and naval operations, to form alliances and make treaties, to contract debts and issue bills of credit upon national account. But these powers were not exclusive. On the contrary, troops were raised, vessels of war were commissioned, and various military operations were conducted by the colonies on their own separate means and authority. Ticonderoga was taken by the troops of Connecticut before the Declaration of Independence was even signed. Massachusetts and Connecticut fitted out armed vessels to cruise against those of England in October 1775, and South Carolina soon followed their example. In 1776, New Hampshire authorized her executive to issue letters of marque and reprisal. All these events and facts are the actions of a sovereign power, and prove that Congress exercised no power which was considered as abridging the absolute sovereignty and independence of the states. Many of those powers which, for greater convenience, were entrusted exclusively to Congress, could not be effectually exerted except by the aid of the state authorities. The troops required by Congress were raised by the states, and the commissions of their officers were countersigned by the governors of the states. Congress was allowed to issue bills of credit, but they could not make them legal tender, nor punish the counterfeit of them. Neither could they bind the states to redeem them, nor raise by their own authority the necessary funds for the purpose. Story states that, in respect to foreign governments, we were politically known as the United States only, and it was in our national capacity as such that we sent and received ambassadors, entered into treaties and alliances, and were admitted into the general community of nations, who might exercise the rights of belligerents and claim an equality of sovereign powers and prerogatives. So let's look at this part of dealing with ambassadors. Congress did receive ambassadors and other public ministers, yet they had no power to extend to them that protection which they received from the government of every foreign nation. In fact, there was a case where a man by the name of de Longchamps entered the house of the French ambassador in Philadelphia and threatened violence to Francis Barbé Marbos. He afterwards assaulted and beat him in the public square. For this offense, he was indicted and tried in the courts of Philadelphia, and punished under its sentence. The main parts of the case focused on whether the authorities of Pennsylvania should not deliver up de Longchamps to the French government to be dealt with at their pleasure. At no point was the federal government of the time ever considered to possess any power over the subject, or was it deemed proper to invoke its council authority in any form. This case occurred in 1784, well after the adoption of the Articles of Confederation. So it's very clear that no matter what power that people think that the federal government of the time had, it was held at the will of the states. So what about treaties and alliances, and claiming equality as sovereign powers and prerogatives? In dealing with other nations, the colonies struck several treaties with foreign nations, but were mentioned individually. The Treaty of Alliance with France in 1778 was made between the Most Christian King and the United States of North America, to wit, New Hampshire, Massachusetts Bay, Rhode Island, Connecticut, and so on, enumerating them all by name. The same form is also observed in the Treaty of Amity and Commerce with the States General of the United Netherlands in 1782, and the treaty with Sweden in 1783. In the Convention with the Netherlands in 1782, concerning recaptured vessels, the names of the states were not recited, but the United States of America is the style adopted. This shows that the two forms of expression were considered equivalent, and that foreign nations in treating with the revolutionary government considered that they treated with distinct sovereignties through their agent. Similar language was not unusual through the whole course of the Revolution. The people of His Majesty's colonies, the people of the United Colonies, the people of the United States, were all forms of expressions which frequently occurred without intending to convey any other idea other than that of the people of the several colonies or states. Finally, in 1782, when the Revolutionary War was finally won, the treaty struck with Great Britain by which our independence was acknowledged proceeded upon the same idea. The first article declares that His Britannic Majesty acknowledges the said United States, to wit, New Hampshire, Massachusetts Bay, Rhode Island and Providence Plantations, Connecticut, New York, New Jersey, Pennsylvania, Delaware, Maryland, Virginia, North Carolina, South Carolina, and Georgia to be free, sovereign, and independent states, that he treats with them as such. Thus, the very act by which their former sovereign releases them from their allegiance to him confirms to each one by name the sovereignty within its own limits, and acknowledges it to be a free, sovereign, and independent state. United, yes, with all the others, but not as forming with them any new or separate nation. And remember, state in that time was used in the same way as we use the term country today. For example, the state of Spain, the state of France, etc. The language employed couldn't convey any other idea. If it had been thought that the states had merged themselves into a single nation, something like the following wording might have been proper. His Britannic Majesty acknowledges that New Hampshire, Massachusetts Bay, etc., former colonies of Great Britain and now united together as one people, are a free, sovereign, and independent state. But that's not how it was worded. It makes it very clear that Britain understands that each state is its own nation. But whatever may have been the condition of the colonies prior to 1781, there is no room for doubt on this subject after the final ratification of the Articles of Confederation. Those articles declare that each state retains its sovereignty, freedom, and independence, and every power, jurisdiction, and right which is not, by this Confederation, expressly delegated to the United States and Congress assembled. We now come to our current Constitution. There are no more quotes to directly give from Joseph's story for us to review anymore, and Upshur accounts for this by stating, "Having informed us that as colonies we were for many purposes one people, and that the Declaration of Independence made us a nation de facto, he now assumes the broad ground that this one people, or nation de facto, formed the Constitution under which we live. The consequences of this position are very apparent throughout the remainder of the work." But Upshur continued to dismantle this line of thinking by continuing on into the Constitution. He begins with the preamble and the beginning part of the document that we all know, "We the people." Surely this part of the document shows that we solidified into one nation and one people. But as Upshur states in his book, history alone can settle all difficulties upon this subject. On August 6, 1787, the committee appointed for the first draft of a constitution submitted the preamble in these words: "We the people of the states of New Hampshire, Massachusetts, Rhode Island and Providence Plantations, Connecticut, New York, New Jersey, Pennsylvania, Delaware, Maryland, Virginia, North Carolina, South Carolina, and Georgia, do ordain, declare, and establish the following Constitution for the government of ourselves and our posterity." On the very next day, this preamble was unanimously adopted. This shows that it carefully preserved the distinct sovereignty of the states and discounts all idea of consolidation. The draft of the Constitution was submitted, discussed, and various alterations and amendments were adopted, but without any changes in the preamble, until the 8th of September, 1787, when the following resolution was passed. It was moved and seconded to appoint a committee of 5 to revise the style of and arrange the articles agreed to by the House, which passed in the affirmative. Now remember, this committee had no power to change the meaning of anything which had been adopted, but were authorized merely to revise the style and arrange the matter in proper order. On the 12th of the same month, they made their report. The preamble, as they reported it, was in the following words: "We the people of the United States, in order to form a more perfect union, to establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America." Since the committee had no authority to change any meaning in the preamble, except for the style, the two, "we the people," versus listing the states individually, were considered substantially the same. This difference was certainly not overlooked, for on the 13th of September, 1787, it was moved and seconded to proceed to the comparing of the report from the Committee of Revision with the articles which were agreed to by the House, and to them referred to for arrangement, which passed in the affirmative, and the same was read by paragraphs compared and in some places corrected and amended. In what particular these corrections and amendments were made, we are not very distinctly informed, but the only change which was made in the preamble was by striking out the word "to" before the words "establish justice." So why the change? The primary reason for the change in the phraseology from the states by name to the more general expression "the United States" was because the revised draft contained a proviso that the Constitution go into operation when adopted and ratified by 9 states. It was uncertain whether all the colonies would adopt the new Constitution, and if they should not, it would be altogether improper to name them as parties to that instrument. For example, Rhode Island was not represented in the convention, and consequently the others had no sort of right to insert her as a party. Hence it became necessary to adopt a form of expression which would apply to those who should ratify the Constitution, and not to those who should refuse to do so. It means simply, "We the people of those states who have united for that purpose, do ordain," and so forth. This construction corresponds with the historical facts, and reconciles the language employed with the circumstances of the case. So that concludes the look of the Union from the standpoint of Abel Upshur and Joseph Story, and the two theories placed side by side. But there is one more point that needs to be covered, and can be considered a turning point for our nation. Many people will refer to the Civil War as being the turning point that settled everything having to do with the sovereignty of the states. But this is a very dangerous stance to take, and one that normally shows that the individual hasn't done much thinking in the way of his position. There are three things to always consider before taking this stance. First, the discussion of the Union is a philosophical argument, and philosophical arguments are not, at least to reasonable people, decided one way or the other by violence. If violence is the only way to deal with issues, then it really is a lost cause. There's not much point in courts, or justice, or anything. Might makes right, and that's about all there is to say on the subject. The argument for the makeup of the Union is not only philosophical, but historical as well. The Compact Theory does describe U.S. history. There's no way to evade that brute fact. The second point is that the Constitution established a limited federal government that left the people in enjoyment of their liberties. If the Civil War settled this issue, then it settled everything concerning it. The federal government officially broke any limitations on its boundaries and utterly destroyed what the Constitution established. You have to remember that the Bill of Rights is part of the Constitution, and that means no more freedom of speech, no more right to keep and bear arms, no more right to privacy in your home, property, or effects, no more right to a trial by jury if the federal government so decides. You are 100% at the mercy of the federal government, and they can do pretty much whatever they want to you, your family, or your property, because any way to limit the government is now gone. And lastly, even after the Civil War was over, a unanimous Senate Judiciary Committee report in January 1872 declared that a construction which would give the phrase a meaning differing from the sense in which it was understood and employed by the people when they adopted the Constitution would be as unconstitutional as a departure from the plain, express language of the Constitution. So there it is, the federal government itself acknowledging that the Constitution was still in force after the Civil War was finished. This was likewise the view of an eminent contemporary, Chief Justice Thomas Cooley, when he stated, "A court which should allow a change in public sentiment to influence it in giving construction to a written constitution not warranted by the intention of its founders would be justly charged with reckless disregard of official oath and public duty." So, which of the two theories is the correct one? Well, like everything else, it's going to depend on the person you're talking to. But as you can see, even the people who went through the Revolutionary War differed on their opinions of its makeup. But for those who choose the nationalist theory, the history they are basing their stance on is on shaky ground at best.